A ladder, a bundle of ransom bills, and a set of handwriting comparisons helped send Bruno Richard Hauptmann to the electric chair. America called it the Lindbergh trial, the trial of the century. But underneath the headlines was a harder question. When the whole country already wants an answer, how much circumstantial evidence is enough for death? The case began on March 1, 1932, inside the Lindbergh home in East Amwell, New Jersey. Charles A. Lindbergh Jr., not yet 2 years old, was gone from his room. A ransom note was found, and the family crisis immediately became a national event. Charles Lindbergh was not only a father, he was one of the most famous men in America. That fame changed the atmosphere around everything that followed. Newspapers, police agencies, private intermediaries, and the public all pressed toward the same question: who took the child? The ransom negotiations eventually ran through Dr. John F. Condon, known publicly as JAFC. According to the state's case, Condon met the ransom collector in a Bronx cemetery and paid money in bills that could later be identified. The child was not returned. On May 12, 1932, his body was found several miles from the Lindbergh home. For more than 2 years, there was no trial. Then a piece of ransom money surfaced. Investigators traced a marked bill to a Bronx carpenter, Bruno Richard Hauptmann. After his arrest, the FBI summary says more than $13,000 in ransom certificates were found hidden in his garage. Hauptmann said the money had come from another man, Isidore Fish. The state said it was part of the ransom trail. That was the first pillar of the case: money. The second was handwriting. The ransom notes contained distinctive spelling and letter forms. Experts compared them with Hauptmann's writing samples and testified that the similarities mattered. Today, handwriting comparison can sound old-fashioned or uncertain. In that courtroom, it helped turn a suspect into the alleged author of the ransom demands. The third pillar was the ladder. A homemade ladder had been found near the Lindbergh home. It fide pilempe crefeture. The prosecution used wood and tool mark evidence to connect parts of that ladder to Hauptmann's world, his tools, his work as a carpenter, and wood said to match flooring from his attic. To the state, those separate pieces formed one chain. To the defense, the chain was circumstantial, and circumstantial proof can look strong only after every weak link is lined up in the same direction. The trial opened in Flemington, New Jersey in January 1935. The courthouse became a stage. Reporters crowded the town. Charles and Anne Lindbergh testified. Condon testified and identified Hauptmann as the man who received the ransom. Hauptmann took the stand too. He admitted lying to police about some things, but he continued to say he was innocent. That is the tension at the center of the trial. No witness placed Hauptmann in the nursery at the moment of the kidnapping. The case depended on what the evidence seemed to connect: the money, the notes, the ladder, the tools, the wood, the alleged ransom meeting. The jury did not need direct eyewitness proof if it believed the circumstantial chain beyond a reasonable doubt. On February 13, 1935, it did. Hauptmann was found guilty of first-degree murder and sentenced to death. The appeal did not reopen the case as a public debate. It asked whether legal error required reversal. In State v. Hauptmann, New Jersey's highest court of that era affirmed the conviction. The court rejected challenges involving the prosecution's summation, the judge's comments on evidence, circumstantial evidence, handwriting experts, the ladder, publicity, and other trial management issues. The United States Supreme Court declined review. That legal ending did not end the historical argument. For decades, writers, researchers, and Hauptmann supporters questioned parts of the investigation and trial. Some claimed evidence had been overstated or mishandled. Those claims belong in the history of the case, but they are not the same thing as a court vacating the conviction. The official result remained: conviction affirmed, clemency denied, execution carried out. On April 3, 1936, Bruno Richard Hauptmann was executed in New Jersey. The case also changed American law. The Lindbergh kidnapping helped lead to the Federal Kidnapping Act, often called the Lindbergh Law, expanding federal authority when kidnapping crossed state lines or involved interstate movement. A family tragedy had become a national legal turning point. So the Lindbergh trial leaves two records. One is the court record, a conviction, an affirmed judgment, and a death sentence carried out. The other is the cautionary record, a trial under enormous public pressure, built on technical evidence that ordinary jurors had to trust, in a case where the demand for certainty was almost unbearable. That is why the case still matters. Not because every later theory is proven, not because the verdict vanished, but because it asks a question every courtroom still has to face. When evidence is technical, public emotion is loud, and the penalty is final, how carefully do we decide what proof really proves?